Dear participants of the third International Scientific Prague Conference, Social Rights and Their Protection by the we continue our work. Now we will start the second session, the present, the second section. Yes. I will be moderating this section. Natalia Kovalenko, judge of the Administrative Cassation Court of the Bay. I'll remind that we have the interpretation. Therefore, possible, do not speak too quickly for our interpreters to have this opportunity to interpret. We have the opportunity to put questions and answers in written. And I also remind you about the time schedule, 10 minutes, up to 10 minutes. Our section, which we will be considering practice of the national administrative courts, as well as the courts of administrative jurisdiction. It is my honor to present to our presenter, Dr. Miriam Meslin, judge of the Federal Social Court of Germany. We are pleased that at this expert discussion, we have the wider circle of experts, and such experts join us, share their very interesting just substantively. Mrs. Miriam, Dr. Miriam Mesland, the presentation of social jurisdiction in Germany as an independent public jurisdiction and what it means for the protection of social rights. You are welcome.
Thank you very much for the warm welcome, dear Mrs. Kovalenko, and I would like to thank you also to the organizers for having been invited to this conference. I'm very pleased that you're interested in our social jurisdiction in Germany, which I will now introduce to you. Ladies and gentlemen, esteemed participants of the conference, dear colleagues, the Federal Republic of Germany has 5 independent branches of law, one of which is our social jurisdiction. Article 1 of the German Social Court Act, the Sozialgerichtsgesetz, which sets out the rule of procedure for social courts, clearly stipulates that social courts are special administrative courts which rule on legal disputes of public nature. However, this definition falls too short. Social jurisdiction is not just a special kind of administrative jurisdiction. It is a completely independent jurisdiction which has developed separately over the decades. It is not only committed to the principle of the division of powers, but also serves to implement the welfare state as set out in Article 20, paragraph 1 of the German Constitution, which we call our basic law. This stipulates that the Federal Republic of Germany is a democratic and social welfare state. Social jurisdiction has a long tradition in Germany. Otto von Bismarck, who was appointed Reich Chancellor of the German Empire, set out to implement a unique set of social reforms. Social insurance laws were adopted, giving workers mandatory health, accident, disability, and old age pension cover, as well as provisions governing substantive rights. The social insurance laws introduced by Bismarck also encompassed a separate procedural law. Special courts of arbitrations were set up with the so-called Reichsversicherungsamt, the German Reich's Social Insurance Office, as the highest authority. This meant that social security legislation was not subject to the existing jurisdiction at the time, and so social security legislation was different from other laws and regulations right from the start. All the same, in its position as an administrative authority and jurisdiction at the same time, the Social Insurance Office represented a departure from the principle of the separation of powers. And so when the basic law, our constitution for the Federal Republic of Germany, came into force in 1949, the need for a change in these structures was clear. Article 20 of the Basic Law stipulated a division of legislative, executive, and judicial powers, which put an end to the dual function of insurance officers, which until then had taken on executive as well as judicial tasks. In Article 69 of our Constitution, the Basic Law expressly referred to labor and social jurisdiction to be introduced by the legislator. With the approval of the Social Court Act in 1953, the legislator determined specifically that the Social Court Act led to the establishment of social courts of first instance, higher social courts as appeal courts, and the Federal Social Court, the Bundessozialgericht I belong to, as court of third instance and court of cassation. The Social Court Act thus established independent jurisdiction on social law. The responsibilities of social jurisdiction are now finally governed by Article 51 of the Social Court Act. These include the key areas of social welfare, social compensation, social aid, and social support. Provisions include the 5 areas of social security: health insurance, care insurance, accident insurance, pension scheme, and unemployment insurance. Social payments provide compensation from public funds for any impairment to health for which the general community bears a particular responsibility, which means, example, compensation for victims of crimes. Social welfare provided as social aid and support in the form of development support constitutes allowances aimed at compensating for particular performance disabilities. Social welfare also includes basic job seekers allowance, or in other words, subsistence securing benefits for those who are essentially able to work. The definitive list under Article 51 of the Social Court Act also makes it clear that legal action may be taken for general administrative jurisdiction for all other disputes in the area of public law of a non-constitutional nature. When it comes to individual disputes, social litigation almost always affects the existence of those concerned and involves some kind of structural inequality. The plaintiffs are normal citizens who have been restricted in their possible courses of action through certain adversities of life changes because they are ill, unemployed or disabled. On the other side is a specialist administrative unit made up by legal experts as well as doctors. Social jurisdiction is therefore an aspect of case law whose judgments on the whole have the most lasting influence on the existence and fate of individuals. Unlike general administrative jurisdiction, it is not influenced by intervention from the authorities. It is more about providing state funds to which citizens have a legal right. Social courts therefore not only ensure the rule of law is maintained, they also guarantee social welfare. More than all other courts, they must take social and socio-political issues and objectives into account. An independent social jurisdiction can fulfill these objectives particularly well. As such, it is the institutional expression of the importance attached by the state to guaranteeing the fundamental rights of individuals. An independent jurisdiction also ensures the necessary level of specialization and knowledge in the particular way. And above all, by setting out its own rules of procedure, the Social Court Act takes the needs and situations of the citizens concerned into account in a particular way, which is a deliberate departure from other codes of procedure. This also ensures a different kind of case law culture. The specialties of the Social Court Act are mainly the following. The significance of honorary judges is of primary importance. The circles these judges are selected from depends on the area of the law they specialize in. For cases involving social insurance and the German Federal Employment Agency, one of the honorary judges, for example, will be selected among the employers and another among the insured. Unlike in administrative jurisdiction, in the court of first instance with just one professional and two honorary judges, the latter have the voting majority in case decisions. They are involved not only in the trial hearing, but also in hearings of the Court of Cassation, and thus in terms of interpretation of law and not only in facts. The strong position of honorary judges has several functions. It continues the traditional participation of the insured parties and the employer in the self-administration of social insurance at a different level. It opens the court up to the knowledge of the concerned parties, since the honorary judges are not standard lay people, but bring their own specialist knowledge of the relevant legal field as employees or employers. And it expands the legitimacy of court judgments in existential cases. Joint decisions made by the insured party and the employer are generally better accepted, even if the decision is not favorable for the concerned parties in existential terms. Moreover, based on the principle of party disposition and the basic principle of official investigation that applies to all public jurisdiction, social court cases are also characterized in many detailed regulations by the emerging principle, which we call plaintiff friendliness. In no other rules of procedure is the work of judges set out in quite the same way. As a general rule, the local jurisdiction falls to the social court in which the concerned party is resident and not that in which the authorities are resident. There are no foreclosure rules, unlike in other rules of procedure. The plaintiff's claims are to be interpreted widely where appropriate. The court has an extensive obligation to supply information so that even those who are not represented may have effective legal protection. Plaintiffs only require a representative at the Federal Social Court of Germany. In the courts of first instance and second instance, it is easy for them to represent themselves. They do not, however, have to represent themselves where appropriate, as in all courts of law, they have a right to legal aid. Court representation is permitted not only for lawyers, but also for authorized trade union representatives, associations which are with a social or professional purpose, or for the employer. Another specific feature of the Social Court Act is that the insured party can arrange for a doctor in whom they trust to attend. This is a legal provision that does not exist in any other rules of procedure. It reflects the fact that in many social court proceedings, it is necessary to collect medical reports, even though the person concerned does not have any influence on the selection of the expert providing their medical opinion. The application to request such a report can only be refused under certain circumstances, for example, if the request is made for the purpose of delaying proceedings. Finally, social court cases are in principle free for all citizens. Since these cases are often vital to the existence of those involved, nothing should restrict individuals' access to such proceedings, including economic circumstances. To summarize, I would like to say that social jurisdiction represents a clearly visible part of the welfare state for all citizens. Proceedings are organized specifically to take the needs and situation of those concerned into account in a particular way and are therefore essential for the protection of the welfare state system. Thank you for your attention.
Thanks a lot. Thanks, Mrs. Mesling. very informative. Of course, very important to have a special social justice, which are actually a separate social code, and it allows to provide for particular procedures. We hope for further cooperation with your institution. Now, I would like to give the floor to Tatiana Ansupova, judge of the Grand Chamber of the Supreme Court, Doctor of Law, Professor. Long ago, Tatiana Ansupova was judge of the Grand Chamber on the protection of social rights of the administrative cassation in the and many revolutionary functions just were taken into account of the presentation, the role of the Supreme Court in the evolution of the social function of the state on the example of modern approaches to resolving pension cases by the Great Chamber. You're welcome. Thank you, Natalia Vladimirovna. Dear colleagues, my pleasure to see you all here on the screens. Our colleagues will take part in this section. My friends from Poland and Germany, it's my pleasure together with you that we were able to implement the idea of organizing this conference together with our partners. Therefore, I would like to thank all the attendees and participants and listeners who are. And now I'll move to my presentation. Please show the next slide. This slide is rather provocative because here Niccolo Machiavelli is cited, which is known never has been a democrat. In order to demonstrate that both in the Middle Ages and right earlier there was understanding that the people, the citizens, individuals have a need in this state, and the state should just substantiate its functioning because of operating pressure. In the present day, in the present Europe, we observe that the democratic values, the rule of law, the protection of human rights, because of the pro-European integration with the creation of such organization, the Council of Europe and the European have become the daily life of all the nature of Europeans. The Europeans, they are 800 million, all in all. We observe the obvious historical progress, the inevitable development of society, to which state institutions should be sensitive. Such evolution in these social relations, it is also stated by the European Court of Human Rights that there is an ongoing unavoidable evolution in social relations. Such an evolution, such sensitivity is inherited to the social function of the state. Looking at the news history of Ukraine, we may say that the development of this social function was not taking place consistently and gradually as it was taking place in the old democracies. As for Ukraine, this change occurred in 1991 when Ukraine acquired independence. And hence, I believe that we observe some problems in this gradual transformation, gradual comprehension. What is the difference of the social function of the Soviet state of the present Ukraine? Regretfully, not all comprehended in this way. We indeed inherited a lot from Soviet times to understand what a social state should be. In 1996, We know that the constitutional foundations of an independent democratic state were formed. Ukraine announced and declared itself a social state. Ukraine has undertaken a high goal as for a country with a economy in transition. And indeed, we observe almost for 30 years that the implementation of this social orientation is rather difficult for Ukraine. There are some objective factors of this. In my presentation, the representative of the pension fund of Ukraine just mentioned about that. A big number just of pensioners, about 11 million pensioners, and also for the ongoing pension reform and the existence of the solidarity system of Ukraine, which never received the sufficient size of funds, and also the collisions in the laws, then also a person of populist laws which cannot be enforced. It comes from their start, they don't have their objective to be enforced that would guarantee God certain benefits to the recipients. And such conditions, the Ukrainian courts and Ukrainian judges exist to take justified decisions. One Yutkivsky, Ukrainian judge, voiced about that when the judge, which is to choose between the legitimate and fair judgment, the most complicated discussions start. These are indeed complicated judgments to be made. This slide represents the part 1 of Article 3, which is mostly quoted in such cases. That is the concept of social value of the human being. There is an opinion this content, the structure of this article is not quite appropriate. If we apply to the notion of the social value, we'll see that that's the value of some phenomenon from there, but not in the compliance with the needs of the society. Saying that individual is a social value. However, this issue is rather arguable. It was also stressed by Judge of the Constitutional Court, Sergei Golovati, that this norm is not well fit. But we'll come back. What is social state? In the daily life of every person under the jurisdiction of Ukraine, this means that all branches of the government in their activities adhere to the anthropocentric approach. The individuals feel themselves secure horizontally and vertically, that the state, by positive obligations, provides for development of the individuals for their dignified existence of the citizens. It's not occasionally that I said that it was stressed by Valentina Denishevska, the president of the Supreme Court, that only through the mutual efforts we may ensure the implementation of this social program. I will add not only joint, but the efforts should be, but they should be systemic in character. Next slide, please. Given this sprouts of the Supreme Court's human-centered philosophy, which have been stated from its start in 2017, cannot be called the ultimate success. And in this This problem of no enforcement is recognized as a systemic problem in Ukraine. The most fair these judgments, if they are not enforced, they would not lead to the proper functioning in the state. That's how the Grand Chamber of the Supreme Court, of which I am the member, can just apply this human-centered approach. It is possible when the Grand Chamber of the Supreme Court just considers model cases, because the model cases of the first instances are administrative cassation courts. Then the Grand Chamber just receive appeals against those judgments where it can express. Then the Grand Chamber may be part of resolving some legal issues. After a court of cassation will submit with the motivation of resolving of an exclusive legal problem through the Grand Chamber. Yet another opportunity to be part of the practice of social matters. The Grand Chamber may act as a court of cassation when the case is transferred to deviate from the previous case law. Of course, this deviation from the previous case law is the most notable demonstration of the evolution in approaches to resolve some categories of social cases, where there is the reviewing of the previous legal position of the Supreme Court. It is worth to pay attention to the development of the concept of stability of state represented by its authorized bodies. As for the violation of pensioners' property rights, there is some practice. Then next I'll explain it, how the concepts of the protection of pensioners' property rights is carried out. Next slide. Just on the screen, you can see the date and the number of the judgment of the Grand Chamber Supreme Court, where there was deviation from the previous conclusions, which related to the reestablishment of the pension benefits paid to citizens living abroad. That's that's to leave from the judgment of 2009. That what should be done to resume the rights. In this case, the Grand Chamber of the Supreme Court, on the basis of the judgment of the Administrative Cassation Court, which also grounded the reasons for deviation. In parallel approach was use of applying Article 46 of the binding pension insurance. According to Article 46, the pension benefits are paid for the past time without any time limit. If were not received, should be paid just without limiting through the time. That's the case that has been mentioned during the conference. That's a model case on the resuming of the pension benefits to IDPs. The same approach was applied as for extending of Part 2 of Article 46, because the court recognized the pension is awarded and granted and then it is only recalculated if there are grounds for that, but the pension is considered to be granted at the moment of awarding it. And the next slide, that's on applying Article 46. You can see the next slide. I may say that the same way this approach of the responsibility of the state in the person of responsible bodies was introduced in such cases where employees of pharmacies were imposed with a burden that is that they didn't carry out the certification. The court stated that is imposed by the laws and law on the relevant regulatory bodies. That is the responsibility for the failure to provide for the certification of jobs and the failure to do it in a timely fashion rests with the owner of the price, but not with the individual. If the state failed to do it, then the court decided that such a responsibility should not be imposed on a person. Can you hear the moderator? No, I hear the moderator. It's already 5 minutes past the time limit. Already ending. Yet another judgment. You can see it in the slide. I won't speak about it. It also cements the same stance which the Grand Chamber developed in the previous case. I may know that in all these cases, the Grand Chamber only supported the conclusions of the judges in the first and the second instances of the courts. These approaches were already introduced, and judges of the lower instances saw it. And the role of the Grand Chamber is to properly evaluate and approve those approaches that are applicable. Thanks a lot for your attention. I won't take any more of your time. Thank you, Tatiana Alexandrovna. We hope that these sprouts, which you mentioned, will be developed next, will be strongly supported by the executive branch. It will be interesting how you combined these with the quotation, because it gives the. Thank you.
Dear participants, I am the moderator and I will be reminding you about the time limits. Okay, I will just raising this sheet for you to see that it's the 9th minute of your presentation and that you have very little time left. And it is my great pleasure to give the floor to Monica Smush-Kulesha. She is the international expert of the Council of Europe on social rights and European Social Charter. She's been in this capacity since 2015, and she's also justice of a judge of the District Court of Lodz Maciej in Poland, a PhD in law and lecturer at the University of Lodz Faculty of Law and Administration in Poland. And she is the author of numerous articles on this topic. She will be speaking about the European Social Charter as an international instrument for protection of social rights and administrative justice, best practices, challenges, and opportunities. The floor is yours.
Thank you very much, Professor Kowalenko. Can I ask for the presentation? Thank you very much. Esteemed participants, dear guests, ladies and gentlemen, it's my honor to be here with you today and to present the European Social Charter as an international instrument for protection of human rights in administrative justice in front of such highly professional audience. As Olena Litvinenko, the head of the Council of Europe office in Ukraine, said in the opening speech, the European Social Charter is a Council of Europe treaty that guarantees fundamental social and economic rights as a counterpart to the European Convention on Human Rights, which refers to civil and political rights, as it has been said a lot of times today. The European Social Charter guarantees a broad range of everyday human rights related to employment, housing, health, education, social protection and welfare, which was also stressed quite a few times today. What is important to be stressed is that no other legal instrument at pan-European level can provide such extensive and complete protection of social rights as that provided by the Charter, which also serves as a point of reference in European Union law. Most of the social rights in the European Union Charter of Fundamental Rights are based on the relevant articles of the Charter. The Charter, as it was stressed by Olena Litvinenko, is therefore seen as the social constitution of Europe and represents an essential component of the continent's human rights architecture. Next screen, please. Concentrating still on some introductory remarks, I would like to stress that the honoring of commitments entered into under the Charter by the state parties is subject to the supervision of the European Committee of Social Rights. Its 15 independent impartial members are elected by the Council of Europe Committee of Ministers for a period of 6 years, which is renewable once. The European Committee of Social Rights monitors compliance with the Charter under two complementary mechanisms. First of all, through collective complaints lodged by the social partners and other non-governmental organizations, which is collective complaints procedure. And the second procedure is through national reports drawn up by contracting parties, and this is the reporting system. Insofar as they refer to binding legal provisions and they are adopted by a monitoring body established by the Charter and the relevant protocols, decisions and conclusions which are issued by the European Committee of Social Rights must be respected by the states concerned, even if they are not directly enforceable in the domestic legal systems. They set out the law and can provide the basis for positive developments in social rights through legislation and case law at the national level. And I ask for next screen. In the next screen, you will see some basic information about Ukraine and the European Social Charter. Can I ask for next screen? Okay. In the screen, you can see the level of ratification of the European Social Charter by Ukraine. Ukraine ratified the revised European Social Charter. It was in 2006, accepting 76 of 98 paragraphs of the Charter, and it hasn't accepted the system of collective complaints. Gray boxes show articles which have been accepted and white ones those which has not been accepted. Just to give you a few examples, Article 14 guarantees everyone the right to benefit from social welfare system. According to Article 15, disabled persons have the right to independence, social integration, and participation in the life of community. Next screen, please. In the next screen, you will see some basic information about Poland because I will give best practice from Poland. That is why I prepared this slide, being very briefly, because of the time, I would just want to stress that Poland is in a little bit different situation than Ukraine because Poland has not accepted revised European Social Charter. Only the first version from 1961 was ratified by Poland. Poland also hasn't ratified the the amending protocol, and also the collective complaint procedure has not been accepted by Poland. Looking at the right part of the screen, you see Polish courts, and you see that administrative courts are separate in Polish legal system, and the administrative court courts include regional administrative courts and Supreme Administrative Court of Poland. In the next screen, you will see best practices from Poland. And first of all, I would like to take a quick look at the statistics. They maybe don't look very well, because we have only over 160 judgments in which the administrative courts turned to European Social Charter. Unfortunately, there is none judgment which can be searched, which can be found in the official database of administrative courts that turns to European Committee of Social Rights decisions, but still there are some best practices which we can share. And in the next screen, you can see one of the examples of such judgments. It's a resolution of Supreme Administrative Court from 2006. Next slide, please. And this case considered, in this case, the court considered interpretation of the term social security under Polish Act on Social Security System. And what is important to be stressed, that the court stressed the importance of the act of ratification of the European Social Charter by Poland, and the necessity to understand and interpret the most important legal terms in Polish acts in compliance with this instrument. The court stressed that the importance and prominence of the above mentioned convention increases, especially in Europe, in the countries that ratified the European Social Charter, and decided that because of this act of ratification, Polish legal terms must be understood in compliance with European Social Charter. Another best practice that can be shared will be shown in the next screen. In this screen, you can see a judgment of Supreme Administrative Court from 2009. Next screen, please. And here the key aspect was interpretation of the regulation of granting pensions as a way of exception for especially vulnerable persons in case of failure to comply with the standard requirements under the legislation on pensions from the Social Security Fund. And in this case, the Supreme Administrative Court turned to European Social Charter while interpreting the scope of obligations of the state under the legislation on pensions from the Social Security Fund, and decided that European Social Charter must be understood as basis for interpretation and application of law by public authority. Next screens, can I ask for another screen? We'll share some best practices from international level. And first judgment which I have chosen is the judgment of the European Court of Human Rights in the case of Demir and Baykara versus Turkey. As it was said a few times today, European Court on Human Rights in numerous cases turns to European Social Charter. In this case, the court considered the scope of the right to organize and paid attention to a negative aspect of this right, and stressed that considering this negative aspect and the way of understanding, the way of interpretation of this right, it largely based on the European Social Charter and the case law of its supervisory organs, together with other European universal instruments. The court found that European Social Charter, and especially its Article 6, which Turkey has not ratified, so even in such a case turned to European Social Charter, which Turkey has not ratified, affords all workers and trade unions the right, which must be understood in compliance with European Social Charter and the decisions of the European Committee of Social Rights. Another screen also shows best practice from European Court of Human Rights. The case has already been mentioned in the first session by Ms. Tatiana Fulej. We have both chosen this judgment. And in this judgment, the European Court of Human Rights also turned to European Social Charter, and which is also very important, to the European Committee of Social Rights, and quoted some interpretation given by this committee. Next slide, please. Here I have chosen a case of Tymoshenko and others versus Ukraine, because this is a Ukrainian case. In this case also, being very briefly because of the time, in this case also the European Court of Human Rights turned to the European Social Charter, and while interpreting basic terms, legal terms. Okay, so concluding and going to the end, next slide please. I would like to stress that European Social Charter can and should be used in Ukrainian administrative justice as instrument for protection of human rights. It should be involved in the process of judiciary by all the participants, all the legal participants involved in this process. And best practices from both national and international levels show that this charter should be especially useful while interpreting legal terms, determining the scope of particular rights and their understanding. Yes, finishing, I will just tell you that the next screens of my presentation give some practical, please share the next screen, give some practical information and give some connected with the instruments that can be used, the HUDOC database, the digest of the case law of European Committee of Social Rights. If the presentation will be shared, you can take opportunity of the links which are given in the next free screens. Thank you very much for your attention. I'm very sorry for exceeding the time.
Thank you, Ms. Musculescu, for this very practical presentation. Really, we still have to do a lot of work to implement the charter in our practices and case law. We have a certain change to our program. Mr. Oleg Prodibus, who was supposed to speak in session 3, will make his presentation now. Sorry, Mr. Wojciechowski. Now I will give the floor to Mr. Prodibus. He is the co-author of comments to different codes, including Code of Laws or Compendium of Laws on Labor. And he will be speaking about correlation of discretion of court and public authority in the process of individual social rights protection. So, Mr. Prodibus, the floor is yours. Good afternoon, ladies and gentlemen, dear colleagues. To the cassation court, cassation administrative court within the Supreme Court for taking pains and organizing this conference. Is the third conference of this kind, and the transitions that were laid down by the Administrative Cassation Court 3 years ago have proven to be very topical and living. So I believe that this tradition will persist in the future as well. Thank you very much. As for the topic of my presentation, the issue of the correlation between the discretion of the court and that of public authorities when social disputes are at stake is very grave. Just the issue of the correlation or balance of discretions in any disputes is of importance. But given that Article 1 of the Constitution of Ukraine announces that Ukraine is inter alia a social state, and that the ensuring of social rights of the people and citizens and individuals under the jurisdiction of the state is the highest social value. I would like to share my considerations or some of my ideas about how these two types um, discretion can be balanced, and how administrative courts, while implementing their function of applying or enforcing law, can at the same time protect the rights of Ukrainians in this sphere. When it comes to the term discretion or discretionary powers, it is not enshrined in the law. There's only doctrinal interpretation and the interpretation by courts, including by the European Court of Human Rights. But I think that the domestic law and the domestic lawmaker should actually give a clear definition of discretion and of the margin of appreciation in very specific cases. Then it would be much easier for Ukrainian citizens to feel protected in the social state and by the social state. When it comes to pension disputes, we've heard from a deputy head of the pension fund of Ukraine, and she complained that the pension fund, while trying to protect rights of the citizens, does not have the financial capacity. And I would like to remind you that 1/3 of all cases that we consider are related to the protection of social, in particular pension rights, which testifies that the legislation that is meant to protect rights of people in the social sphere is not perfect. And second, that public authorities, to my mind, do not fully protect the rights of citizens by applying certain norms of the social law. And in this very case, the administrative court steps in as an institution that should be very vigilant when it comes to protecting social rights. The question is, what are the margins of appreciation whereby the court can assess certain decisions of public authorities?
Які захищають
Уже
соціальні права,
читаю, давай.
в якому обсязі?
And to what extent can this be done? I believe that proceeding from the practical developments and from case law, we can see that courts recognize certain decisions of public authorities as unlawful or illegitimate, and that is it. As a result, citizens have to go to courts again and to seek redress in courts again. Another approach that some of the courts have taken on is not only to deem certain decisions of public authorities unlawful, but also to encourage them to commit certain actions to practically protect social rights of the citizens. And I believe that it is a very correct avenue of action. The question is whether the court assumes uncharacteristic functions, whether it assumes powers of public authorities, of executive authorities. I don't think it is the case, because as we all know, the major objective of administrative justice is to effectively protect citizens' rights by fairly considering their cases and their disputes. So when it comes to this discretion of the court on the one hand and public authorities on the other, it would be correct, I believe, for courts to motivate their decisions and channel their decisions towards the full protection of social rights of the citizens. It hurts me that some of the public authorities that execute public functions or state functions in these spheres oftentimes fail to respect and protect human rights. Not only am I speaking here about the overloading of the huge pressure of the caseload on the administrative courts, but it is also pressure on the citizens. And as I said before, 1/3 of all cases that administrative courts consider today are about social rights and about complaints on a violation of pension rights, first of all. So it is a result of imperfect legislation and of imperfect exercise of powers by public authorities. Now, speaking about the function of the court, I will perhaps reiterate yet again, and it is a very topical issue, that courts should clearly define the rights of the citizens to the extent they are violated by public authorities, identify this extent, and if it is the case, then they should encourage or force the public authority to take actions envisioned by law and actually point to the legislative provision that the public authority is to honor, is to observe. I will give you an example of case 227 of 2016, whereby the court stated that the effective remedy is the one that results in the necessary implications or results, and the effective remedy should ensure the reinstatement of the violated law and thus make it not necessary for the citizens to seek redress again. So this will be the end of my presentation, and I hope that when it comes to a good balance between the discretion of courts and that of public authorities, courts will continue fulfilling their high mission of protecting human rights and acting within the scope or ambit of Article 3 of the Constitution of Ukraine. Thank you very much. I hope that I kept within my time. Thank you, Mr. Prudivus. Thank you for your keeping within the time limits. I'm sorry I mispronounced your second name. Then I would say that the issue that you've raised is very relevant, not only in respect to administrative cases or social rights protection, but the interference of the courts sometimes is necessitated by effective protection of those rights. And oftentimes the person or the individual has to seek redress again, because even if their claim is satisfied, but it is satisfied only partially. If I may add here, I will give you an example whereby plaintiffs, individuals need to go to court several times repetitively with the same case, with the same complaint, to have their right reinstated, because the decisions that actually recognize the unlawfulness of decisions or acts of certain public authorities do not reinstate those rights as a result. Thank you very much. Thank you very much. And now we will give the floor to our next speaker, that is Bartosz Wojciechowski. He is judge of the Financial Chamber, head of the European Law Unit of the Supreme Administrative Court in Poland. He is director of the Center for the Theory and Philosophy of Human Rights, doctor of law, professor of law in the University of Lodz, Poland, and he is our long-standing friend and expert, and he's a very reliable partner who we know and who we treasure, and whose friendship and expertise we treasure. And we thank you for taking part in this.
Dziękuję, Natalia.
In this conference. Will you present your topic, or shall I? Okay, I will. The topic is principle of equal opportunities and equal treatment of men and women in matters of employment and occupation. Practical case.
Thank you very much. Ladies and gentlemen, I would like, first of all, I would like to thank the organizers, especially Justice Dan Professor for the invitation. As always, it's a great joy and honor for me to participate at the conference in Kiev, even online. I would like to start with, I have presentation, but I don't know if I can use this here. Okay, maybe next slide. Next. I'm sorry, could I please, and after this next slide too, I would like to talk a little about the understanding or the meaning of these principles, or these principles, the principle of equal treatment and the principle of non-discrimination are fundamental to the functioning of a democratic state ruled by law, and are regulated by the Constitution of the Republic of Poland and by European Union and international law, of course. The difference between the scope of their content is worth noting. Equality differs from non-discrimination primarily in terms of the nature of the obligations incumbent on public authorities. Thus, in the case of equality, these obligations are positive in nature and consist in taking specific action to achieve equality. With non-discrimination, however, the obligations are of a negative nature and consist in refraining from certain actions which infringe the principle of equal treatment. The principle of equality encompasses the obligation of equal treatment, protection against discrimination, and also the prevention of inequality. It therefore requires that two entities in a similar situation should be treated in the same way and differently in a different situation. If two persons having the same characteristics that are relevant in a given context are treated differently, then this constitutes discrimination unless there is an objective and reasonable justification for such unequal treatment. At the same time, the equal treatment of persons significantly different from each other in terms of the relevant characteristics also constitutes a discrimination. Next slide, please. The legal problem in our case, in the cassation appeal filed with the Supreme Administrative Court against the judgment of the District Court, Administrative Court in Warsaw case, it was alleged that there had been an infringement of Article 145 paragraph 1 and 1a of the Act of the Law of Proceeding before Administrative Courts, due to the dismissal of the appeal at first instance in a situation where the contested decision was adopted in violation of inter alia Directive 2006 of the European Parliament and the Council of 5th July 2006 on the implementation of the principle of equal opportunities and equal treatment. However, the applicant in this case does not state the specific grounds for deducting that the decision to dismiss her from service infringed Directive 2006. Next slide, please. And this is a context of European law. And maybe next slide. Court of Justice's case law confirms that maternity is inextricably linked to sex as a legally relevant and protected characteristic. Since the unfavorable nature of a woman's position in employment during pregnancy, including during or after maternity and parental leave of or after retiring from it, may primarily affect women, and any discrimination on grounds of maternity will constitute discrimination on grounds of sex. And we have a lot of judgments about this. Next slide, please. And this is a Polish law, Polish context. The applicant in our case was dismissed from service pursuant to Article 41 in connection with Article 43 and Article 45 on the Polish Journal of Laws of the Republic of Poland. In accordance with the content of this provision, a police officer may be dismissed from the service if an important service interest thus requires. The case law of the administrative courts is uniform with regard to the understanding, interpretation of the premise important service interest, and leaves no doubt that the long-term absence of a police officer from service and above all negative consequences of long-term and constantly repeated sick leave may justify termination of the service relationship with a police officer on the basis of this article. The existing national legislation does not differentiate between men and women on police duty in this respect. Next slide, please. At the same time, this article introduces an exception to the principle of the special protection of women during pregnancy and maternity against dismissal. It follows from this regulation that a police officer may be dismissed during pregnancy if the basis of dismissal is inter alia Article 41. In the context of the case pending before the Supreme Administrative Court, case file, it should be borne in mind that Article 44 of the Police Act must be interpreted strictly and applied exceptionally when no dismissal could actually expose an important service interest to serious losses. Due to the lack of specification in the cassation appeal of exactly which provisions of Directive 2006 were breached by the order for dismissal under Article 41, it is difficult to determine whether a breach of the directive by the public authorities action, which consisted in dismissing a police officer because of an important service interest, actually occurred. In conclusion, the SAC hearing the case in question should take into account the facts of the case. However, it is necessary for two situations to be distinguished. Next slide, please. My opinion about this case in the dismissal was made on the basis of Article 41 for reasons and as stated by the authority in the personal decision order other than pregnancy and was justified by an important service interest. It cannot be said that a breach of the principle of non-discrimination had occurred, and thus of Directive 2006, such a decision is taken within the scope of administrative discretion, and in this case, judicial review is limited in that the court examines only the legality and not the admissibility of such a decision. Next slide, please. If, on the other hand, the reason for the dismissal was applicant's long-term absence and pregnancy, and decision-making authority misused its powers of appealing to Article 41 in conjunction with Article 44, and to that end, by invoking the concept of an important interest of the service, then there was a breach of the principle of non-discrimination and consequently of Directive 2006. However, the appreciation of the facts from which it may be presumed that there has been direct or indirect discrimination remains a matter for the relevant national body in accordance with national law or practice. Next slide, please. It seems that insofar as the SAC is bound by the limits of the cassation appeal, it is significant that the established facts are not disputed. It can be concluded that in the present case, there was no breach of the principle of non-discrimination and thus of Directive 2006. At the same time, the problem of the correct implementation of directive in the national legal order may be considered, taking into account the principle of equality between women and men, as set out in Article 2 and 3, and the prohibition of any discrimination on grounds of sex contained of the Charter of Fundamental Rights of the European Union. Therefore, if it's considered that Article 44 and taking into account that it was pregnancy which constituted a decisive argument for termination of this relationship and thus exposed an important service interest to serious losses, a basis for dismissal under Article 41, we can say that the above mentioned provisions of the Acts of European Union and treaties of European Union and the Charter of Fundamental Rights do not preclude such national regulation. For example, the case about Küçükdeveci, Seta Küçükdeveci. Next slide, please. And we have now the decision of Polish court, and the most important is the phrase "may be dismissed," used in the aforementioned provision, and entails the decision in this respect are taken within the scope of administrative discretion and are of an optional nature. Contrary to the suggestions made by author of the cassation appeal, is it the substantive law applicable?
Пане Bartosz, нагадую про час.
Okay. I would like to
and about time
finish.
limits, okay?
Maybe to the end. The next slide, please. The expression important service interest referred to in this provision may therefore cover various factual situations where the need to protect the service interest, social interest, as an overriding interest justifies dismissing a police officer from service, and it is not possible to terminate the service relationship with him, her on other statutory grants. Of course, the justification is more complicated and sophisticated, but we don't have time for this. Dziękuję za uwagę.
Дякуємо, Бартоше Войцеховський.
Thank you, Bartosz. for a very interesting presentation. Our next speaker is Ms. Eurydita Brieda, Judge of the Administrative Department, the Supreme Court of Latvia. Again, yet another great friend of Supreme Court of Ukraine. She has been working with us for several years, and in 2017-2019, she was an advisor and consultant of the EU project implemented here in Ukraine. And I know that that project was most effective and efficient, particularly given that at that time the new Supreme Court was at the stage of formation and of changing practices, and you've proven to be extremely consummate professional and extremely friendly and trying to help us. Ms. Brieda will be speaking about status of undeserved individual and relevant proceedings in administrative courts of Latvia. Thank you.
Okay, thank you very much for presenting myself. So I'm very glad to meet you all, at least online. Of course, I would be much happier to meet you in person, but life is life, and it brings changes in communication as well. So in my speech, I will touch on some issues related to the status of low-income person in Latvia, and I will not talk about the complicated interpretation of rules. They are most likely related to specific situation in Latvia. It would be very hard to explain complex regulation and its solutions so that they cannot be understood by foreign colleagues as well. Therefore, I will only outline the general rules on the status of the low-income person in Latvia and share some experience of administrative courts on some issues that may be of interest and relevance to Ukrainian colleagues. So the Latvian state has introduced a number of benefits for low-income families and individuals in various areas. For example, they receive free legal aid, reduced electricity bills, 90% real estate tax rebate, an exemption from a patient's contributions to healthcare facility, full reimbursement of medicines or medical devices, and the reduced fees for visits to several cultural institutions. And consequently, individuals with low incomes are interested in receiving this particular status. And we have law on social services and social assistance, and this law obliges the Cabinet of Ministers to determine the preconditions for recognizing a person as low income person. And the Cabinet of Ministers adopted regulations, and according to this, the person shall be recognized as a low income person if its average monthly income during the last 3 months does not exceed a specific amount of money. And if it does not own cash savings or property that can be used to improve its material condition. And there are also some other preconditions, but there are usually no disputes about them, so I will not mention them. And there have been disputes in the courts over what should be taken into account when assessing monthly income of person. For example, there was a case in which the legal question was resolved as to whether a loan received from another natural person for the purpose of making mortgage payments for a person's home should be integrated in the declaration of means as a personal income. And the Supreme Court concluded that those funds from the loan received could be considered as income, even if in the formal sense of accounting, a person's balance sheet of assets and liabilities does not change, and person has a counter obligation to repay it, it is relevant in the context of providing social assistance whether the person is able to cope with life difficulties. If a person uses this received loan to cover his or her basic daily needs, and if these funds help the person to overcome life difficulties, then not to include these funds in the person's income would be contrary to purpose of social assistance. So, then a number of disputes have been heard in the administrative courts as to whether the person own a property that can be used to improve its material condition. For example, is real estate owned by a person to be considered as such that is exclusionary circumstance for granting the status of low-income person? There was a case when a person owned a house. She lived in one apartment of this house, but 3 apartments were rented to other people. And she was refused the status of low-income person because she owns real estate, and which she can use it to improve her situation. The person applied to the administrative court complaining that it is not possible to make a profit from the real estate because the building is in poor technical condition. Therefore, the apartments can be rented only for a small amount, as well as the tenants often do not pay rent. So the applicant has to pay for tenants' utilities. But the court rejected this argument, saying that whether and to what extent the applicant actually made a profit from renting the property depend on the applicant's conduct with his property, her property. In reformulating that finding, the court actually found that the person could improve her financial situation on her own, but she did not do so. And it should be noted that Supreme Court decided this case by a judgment and not by a simple refusal to initiate cassation proceedings, as usually in Latvia the case where there is no significant issues of interpretation of law. And since the court has had doubts as to whether or not the technical condition of the building should be taken into account. I don't know what my colleagues discussed at that time because I was in Ukraine at that time. But in fact, the court could have come to the opposite decision, saying that although the prerequisite of technical condition is not explicitly provided by law, it should be there, or it should be understood that it is there. Namely, it is possible that legislator has not even imagined such a situation when, despite the fact that the person owns property, it would be fair, however, to provide assistance to a person who owns a house in poor technical condition and in which he or she lives. And in such cases, the court may apply the methods of further development of law and interpret the legal norm by extending its verbal scope. Besides, the Supreme Court has recognized in another case that the condition for granting the status of low-income person should be such that they do not force a person to lose his or her only house. No, however, the Supreme Court in the above-mentioned case adhered to verbal text of the norm without extending it. Then administrative courts have also considered disputes arising from the unjustified granting of low-income person status. These cases usually involve not only status issues, but also the obligation to repay the benefit received illegally. And there is article in the law which provides that the competent administrative authority shall take a decision on recovery of a social assistance benefit paid if it detects that the relevant benefit has been paid out unjustifiably due to the fault of the client, if the client has provided false or incomplete information or failed to notify regarding changes that may affect the rights to such benefit or the amount thereof. For example, there was a case in which the mother has stated in declaration that she maintains 3 children and all children live with her. She was granted the status and also benefits, and the competent authority administrative body later learned that one of applicant's daughters did not actually live in the applicant's home in Riga for most of the period for which social assistance was granted, and that she did not share the applicant's family basic expenses at that time, as her basic needs, including housing and food, were provided by grandmother living in Luxembourg. And the competent administrative authority annulled its decision to grant the benefit and ordered the repayment of money paid to the applicant. In the court, the applicant argued that benefits received has been used for her daughter's needs. However, the court concluded that this was irrelevant in the present case because family law and social rights have different views on family members. And from the point of view of social rights, the fact of living together is important. So I will now end my short report. Thank you very much for your attention.
Thanks a lot. Indeed, in cases on the status of low-income persons, courts should pay attention to details. Thank you. The next speaker, Anton Matayenko, who is the head of the Center for Investigation Issues of Administrative Justice of Kyiv Regional Center of the National Academy of the Legal Sciences of Ukraine, member of the Scientific Advisory Board of the Supreme Court, Doctor of Law Professor. Topic of his presentation: solution of several categories of public legal disputes in the sphere of military servicemen rights protection. Thanks a lot for this opportunity to speak. I would like to thank also the Administrative Cassation Court for this invitation and for the opportunity to make these remarks at this respected international scientific and practical event. In practice, I will try, as Judge Stetsenko said, this conciseness is the sister of the talent. I'll try to get into relation with this sister and to put forward key messages on my presentation. In practice, more often, military servicemen apply to courts for the protection of the rights that were violated, particularly that were violated by military units, and different reasons. In one of the administrative cases, the complaint of the person was motivated. There were no grounds for the continuation of the contract on military service in the military units of the internal guard, National Guard, that was concluded in 2003 between the plaintiff and the military unit for the term of 3 years, because at the end of the contract, the decision on mobilization was not made, and the mobilization did not last, and therefore the special period in Ukraine was not in effect. Thus, in the opinion of the plaintiff, indicates the absence of the legal grounds for denying him. Courts came to the conclusion that the plaintiff, that is, the defendant, the defendant, while continuing the contract, acted on the grounds and within the basis that was established by the relevant laws of Ukraine, because the special period came into force, and therefore the contract is prolonged until the demobilization is announced. If we read attentively law Ukraine on the military duty and military service, which specify the terms of the military service, there is a special article in case of the special period for military services that are in service under the contract, the contract may be prolonged over the specified terms up to when the demobilization is announced. Also, according to the law on the military duty and military service, the wording that was in effect, and the time of emergence of the contract is terminated prematurely. That at the moment of the emergence of the dispute, the term of the contract of such military servicemen could be prolonged under the condition that the special period is announced or before the announcement of the decision of the demobilization. The special period starts when the special mobilization period is announced by the President of Ukraine. This legal stance has been corroborated in many judgments of the Supreme Court. For example, the judgment of 2018, April 25th. Such notions as mobilization, special period, demobilization are specified in the laws on mobilization, on partial mobilization, and if we look into the definition of these notions, then one can say that the duration of the special period starts from the moment when it is announced when the president announced the mobilization, and this period lasts till the president announces the mobilization, or that the special period is terminated. It should be stressed that in this special period includes the time of mobilization, the wartime, and the period in some time span after the hostilities are ended. In view of the effect of the decrease, just some decrease of the president on the partial mobilization that were passed in 2014 and in 2015, then as of September 2016, for example, the date 15th of September, this was the date when the contract of the military servicemen terminated. Then the decision on the mobilization was not made by the president. Mobilization was not light. The special period was not in effect. Why the special period was not in effect? The thing is that the special period, just time is limited by terms which relate to the mobilization or the time span during which the war situation is in effect, or after the period when the hostilities have ended. In case that the war was not announced, or in case of there was no decision on mobilization, or the terms terminated for the conduct of this mobilization, there is no effect of the special period. In 2014, 2015, this special period was in effect with some time intervals. If we analyze all decrees of the president issued on announcing partial mobilization, we'll see that basically starting from the 23rd of August 2015, the special period was not in effect. And because of that, automatic prolongation of the contract with the soldier was the violation of the law. So it proves that the absence of grounds for the prolongation of the contract by the military unit over the specified period. Well, and which starts when the decision is announced about mobilization and ends when the decision is announced either about demobilization or because of the termination of this special period. For the termination of the special period, there is no need to make a special just decision on demobilization. It is indicated by Part 3 of Article 3 of the Ukraine military services. There is sufficient ground for the stopping of the special period may be the moment of its ending. Therefore, as of the time of the expiry of the contract of the military servicemen with the military union, it was the September 15th, 2016. The special period was not in effect in Ukraine because as of September 15, 2016, the decision on demobilization was not taken. Mobilization didn't last. What indicates about the absence of the grounds of the need to keep that soldier over the period. Thank you for your attention. That will be the end of my remarks. If there are questions, I will be ready to answer them. Thank you. Thank you, Professor Manayenko. You've been clear and cut about the time schedule. So it also provides clear connection between the theory and practice. Because judicial practice is also the source for our new decision. Thank you. Now conference. So we should end at 3 p.m. But we have here 4 speakers to please keep to the time schedule. Therefore, thus you'll have 6-7 minutes for the national expert council. Sustainable democracy in Ukraine.
Sustainable democracy in Ukraine and
The development of the lesson decision. Alla Fedorova
solution.
is the associate professor of the comparative law of the Kiev National University, named after Shevchenko, candidate of liberal sciences. In addition, secretary of the National University, deputy chief editor
editor in chief of the International Law Journal. She's been a certified trainer of the health
more time is needed to inform about your activities. Please introduce your remarks. Standards are ensuring the standards of protection the rights of IDPs.
About European standards of protecting
that is key
social rights
norms
of
provisions
IDPs
of the European.
And made issues of applying the revised European Social Charter by by Ukrainian courts. Sorry. Thank you very much for this opportunity to talk on the rights of internally displaced people in Ukraine. Until today, they have to fight for their social rights, including their incomes, pensions, etc. Can we pass to the next slide, please? And I would like to draw attention of the esteemed justices to the help distance learning course on IDPs. This distance learning course has been implemented together with the National School of Judges quite successfully. About 80 judges have been certified, and we invite you to join in and to learn this course. Now returning to IDPs. IDPs are believed to be one of the most vulnerable groups of the population, and most often they face the issue of exercising their social rights. As of late 2019, there were more than 50 million IDPs in the world, and you can see here that there are twice as many IDPs as refugees, but somehow courts are seem to be more concerned with the issues of the refugees.
З держав Ради Європи,
IDPs
держав з цим стикалися, в тому числі і Україна, і що і ще Україна посіла фактично перше місце за кількістю внутрішньо переміщених осіб. Але незважаючи на тривалу історію внутрішнього переміщення, уразливість цієї категорії населення, необхідність їх захисту на сьогоднішній день жодного міжнародно-правового договору прийнято не було. Фактично, якщо ми говоримо про міжнародні універсальні стандарти, то вони сконцентровані в двох універсальних документах. Це керівні принципи ООН з питань внутрішнього переміщення осіб і принципи Пінейру. Це ті принципи ООН, які регулюють питання реституції житла і майна біженців. Але, прошу, наступний слайд. Але в Європі всі основні стандарти і підходи до захисту внутрішньо переміщених осіб було розроблено і прийнято саме в рамках Ради Європи в резолюціях і рекомендаціях статутних органів цієї організації. Ну, зокрема, можна відмітити рекомендацію Комітету міністрів державам-членам щодо внутрішньо переміщених осіб, принципи Паулсена, рекомендацію Парламентської асамблеї «Забуті люди Європи», резолюцію Парламентської асамблеї про гуманітарні наслідки та права внутрішньо переміщених осіб. Ну, а також приймалися акти, які стосувалися конкретних вже країн, що стикалися з внутрішнім переміщенням і зі збройними конфліктами, зокрема. Наприклад, в 2018 році було прийнято резолюцію Парламентської асамблеї про гуманітарні наслідки війни в Україні. Ну і відсутність спеціального договору щодо захисту прав внутрішньо переміщених осіб не позбавляє їх тих прав і свобод, які належать їм, як і всім іншим категоріям осіб, і які мають гарантуватися їм так само, як і решті населення держав. Права внутрішньо переміщених осіб неодноразово ставали предметом розгляду в Європейському суді з прав людини, в Європейській комісії соціальних прав, тобто розглядалися в рамках двох фундаментальних договорів Ради Європи, що становлять основу всієї європейської системи захисту прав людини. Мається на увазі Європейська конвенція з прав людини і Європейська соціальна хартія. Причому текстуально права саме внутрішньо переміщених осіб в цих договорах не відображені, але завдяки еволютивному розширенню тлумаченню Європейським судом положень конвенції, сьогодні можна говорити, що такі питання, як там питання соціального і пенсійного забезпечення внутрішньо переміщених осіб, включаючи призначення, виплати, перерахунок пенсії, соціальних допомог, виплати заборгованості по ним, питання заборони дискримінації в отриманні соціальних виплат і пенсій, забезпечення адекватним житлом, питання освіти, мови, навчання підпадають під захист Європейської конвенції, так само, як і питання отримання і поновлення втрачених, загублених документів внутрішньо переміщеними особами. Причому я говорю не тільки стосовно паспорту, але і тих документів, які підтверджують стаж роботи, підтверджують там групу інвалідності, ну і так далі. Ну і інші соціальні права внутрішньо переміщених осіб також можуть захищатися завдяки саме Європейському суду з прав людини в рамках Європейської конвенції з прав людини. І можна відмітити, що вітчизняні суди, вони застосовують все частіше відповідну практику і правові позиції Європейського суду. Зокрема, на цілу низку рішень Європейського суду з прав людини посилався і Касаційний адміністративний суд у відомому всім рішенні, яке сьогодні...
Я перепрошую. Немає перекладу, давайте з'ясуємо, в чому справа. Перекладачі, ви нас чуєте?
Можливо, знаєте, хочу вкластися в 7 хвилин, які...
No, I'm here. Okay, sorry.
Технічно. Добре, так. Добре, дякую. Так ось в цьому
Okay, so
Ми хочемо дослухати вашу доповідь в повному обсязі.
you will have enough time, don't hurry so much. Yeah, so I bring together two topics in this presentation, and I'll try to speak appropriately. In the pilot case that has been mentioned today, in the judgment, pilot judgment on the cessation of paying pensions to IDPs of May 2017, there was a referral to a whole range of the European Court's judgments. But if we analyze case law, including that of the Supreme Court, we will see that there are very few judgments of the European Court for Human Rights that are being applied when certain pension cases are being considered by domestic courts. First of all, it's Pichkur versus Ukraine. And even with the positive resolution of such cases by Ukrainian courts, when it comes to IDPs, the execution of such decisions is an outstanding issue. And Ukraine should do that as part of its enforcement of the ECTHR judgment in the case Burmich versus Ukraine. The European Court also considers issues pertaining specifically to IDPs, particularly in the Balkan countries. And the best known cases in Ukraine are Grubic versus Serbia, Pejic versus Serbia in 2014-2015. The European Court reiterated its position about the actually deprivation of the senior citizen of pension, which is the only source of existence, and it cannot be justified by any social interest. But European Court is fairly accurate and careful when it assesses the position of the states in pension allowances and other social allowances, underscoring that it is within the margin of appreciation of the state to establish their own social protection or social welfare systems. On the other hand, European Committee for Social Rights actually does not allow as much margin of appreciation to the state. According to the European Social Charter, IDPs' rights were also considered by the European Committee. For example, the Center for Housing Rights and evictions in Croatia. Besides, in the recommendations to Ukraine of March this year, the European Committee required that Ukraine should improve its performance because the percent of IDPs provided with state-owned housing is only 7%, which is very low. And as for the right to housing, the European Court actually pronounced its position in the case Siginadze versus Georgia, and this can be a very important case when it comes to the housing rights of IDPs. So IDPs have similar rights to all other people under the jurisdiction of the state, and the responsibility for the protection of their social rights, according to Principle 3 of the UN Guiding Principles, is laid on the public authorities. However, Ukrainian law with regard to IDPs is not always perfect, to say the least, and the European Commission, this European Social Charter, provides the actually the foundations and the legislative framework for the protection of it. And the European Court and the European Committee should be positively reflected on the protection of the IDP's rights.
Прошу і наступний слайд. Адже європейська
My second part of the presentation is about the European Social Charter, which is a very important document. And in the previous section, we discussed it, and some of our colleagues actually commented on how Ukrainian courts refer to this charter. So when it comes to social rights, actually the good practice or the best practice is not to refer to the ECHR, but rather to the European Social Charter of 1961 and revised of 1990, which was ratified in Ukraine. Ukraine ratified it 13 years ago, and
в Європейській соціальній харті закріплені всі відомі трудові.
You know that all known social rights are reflected in the European Social Charter, as Monica told you before. Ukraine actually acceded to almost all provisions of the Charter, but the implementation is a different cup of tea, and Ukraine does not even make 50% of its commitments under the Charter. Sometimes in the recommendations, there would be one or two positive opinions, but for the majority of cases, we do not meet our commitments, and it is up to the judicial system to change the situation. European Social Charter is a living instrument as well as the European Convention, and it is being developed. It creates ever new practices, and this European Committee provided a very detailed interpretation of the major types of social security and social assistance, fair remuneration and fair salaries to actually be sufficient for decent living. Can social allowances be reduced, etc. And the European Court, when it applies the case law of the committee, and sometimes committee applies case law of the European Court, and sometimes even the EU Court of Justice would refer to the case law of the European Committee. We believe that the case law of the European Committee should be summarized, and this idea was vented back in 2008 and 2013, and certain petitions were filed with the Supreme Court to this effect. And I try to actually somehow bring together all the information that I've got about the application of the Charter in Ukraine by Ukrainian courts. Oftentimes, the Charter is just mentioned as an additional source of law, in addition to the international covenants and to the European Convention. But by and large, in searching for such decisions, I could only 1,000 of such referrals. Of late, the number of such referrals has increased, particularly in the decisions and the judgments of the Administrative Cassation Court, but in principle, the situation has not changed. Whereas earlier, court decisions referred to specific points that are not ratified by Ukraine. Today, courts usually refer to part 1 of the Charter, which actually describes the principles rather than to specific articles describing and detailing those principles. And you can see some of the cases and some of the judgments with the referral to paragraph 23 of the Charter. And the absence of referral to the case law and interpretation of the European Committee with regard to certain provisions of the European Social Charter. And the next slide, if I may. Thus, even though the Supreme Court is increasingly more often is referring to the social charter, and the category of cases is being expanded. When it comes to IDPs, pensions to people living abroad, and pension issues in general are not in the focus of attention of our judiciary. So administrative courts can take the lead and actually apply case law of the European Committee to change the situation with the implementation of the European Social Charter standards in Ukraine. A lot needs to be done, and we should start with certain trainings with translation of the case law of the European Commission Commission of Social Rights, because no such decisions have been translated into Ukrainian so far. Thank you very much. Should you have any questions, I will be glad to answer them. I would like to thank Anna Fedorova for a wonderful and very illustrative presentation. Of course, her remark as to the lack of referrals to the Charter and to the case law of the Commission are very true and very well justified. Thank you very much. Our next presenter is on the one-time monetary allowance to military personnel, and it will be Mr. Starodub, judge of the Supreme Court in the Administrative Cassation Court. He is one of the most experienced justices of this chamber. The floor is yours. Thank you. Good afternoon, dear participants of the conference. Given that we have very little, I'll be very brief and to the point. If we could look at the issue of a one-time monetary allowance to the military personnel and issues that arise in courts in this regard. The armed forces of Ukraine fulfill a very important task to protect the territorial integrity and national sovereignty of Ukraine. So the social protection of the military personnel is of great importance, and it should be in the focus both of the executive powers and of the judiciary as well. So particularly given the number of disputes that we have on our hands in administrative courts. The issue of social protection of the military personnel is dealt with in the law of Ukraine on social and legal protection of military personnel and their family members. And one of the major provisions is about the payment of one-time monetary allowance. One may say that it's just one of the measures or means of social protection of the military personnel, but it stands apart from other measures or means because it is a compensation of sorts for the damage to the health and sometimes even loss of life of the military personnel due to the specific character of their service. And this very type of monetary assistance is regulated by Article 16 of the above mentioned law. And the term one-time monetary allowance can be defined in two ways, according to the subjects and according to the severity of the impact on their life and health. When it comes to the subject, these are military personnel themselves, just conscriptees, reservists, members of their families, their parents and their dependent family members, or the survivors. As for the severity of the impact, one can speak about the death of the military service person's disability or partial loss of ability to work without officially recognized disability. So the law on social protection of the military personnel and their family members and the norms regulating legal relations pertaining to the one-time military allowances have been changed fairly often. These frequent changes in the legislation actually create additional problems with the application of the legislation. As a result, different parties to those disputes interpret and understand those notions differently, and that actually impedes the proper application of those provisions by courts. For example, the law provides for the opportunity for the Supreme Court to consider these cases as pilot cases, and so that a uniform and consistent case law is formed. A very bright example of the difficulties with the application of a law in this category of cases is that Supreme Court has considered such cases many times before, and I will comment on some of them. It's the case on the time frames within which the active military personnel has the right to get this monetary allowance, about the need to confirm the reasons and circumstances of their wounding or harm to, or injury, or harm to the health, and as to the amount of the payment. Moreover, the chamber in the Supreme Court is now is pending consideration of a case about establishing disability after the severity of the loss of ability to work was established. Next slide, please. Summing up, the issues relating in the case law to the issues about one-time monetary allowance to the military personnel, we can speak about certain facts of importance for the correct motivation of the court decisions. These are the grounds for paying such one-time monetary allowance. That's the death of the military service person, disability or partial loss of the ability to work without a recognized disability, category of the military service time of establishing disability or loss of ability to work, just the time of a repetitive medical examination, and the time of applying for the allowance. Given that we have very little time left and wishing to give the floor to other participants as well, I would like to stop here and thank you for your attention. And if you have any questions, I'll be glad to answer them. Thank you. Our next speaker is Yaroslav Lazur, Dean of Legal Department, Uzhgorod National University. He is Doctor of Law, Professor, and he perceives jurisprudence as the science or as the theory about fairness.
Thank you, Ms. Natalia. Indeed, I perceive it in that way, and I'll try to confirm it to be maximum laconic, because during the time for the break is not interesting. I would like to thank the organizers, those who have just facilitated the conduct of this event. These very relevant issues were discussed. I would like to say that the range of the issues discussed already demonstrates the progress we made in the judiciary, both theoretically and practically. For example, just issues of the potential capacity of the administrative courts. And there is only the need to develop the practice and the institutions that would develop this area of justice. I would like to draw the attention of the participant to the acts of planning as topic, as a subject matter for the appeals in administrative courts. Why I chosen this topic? Because this is very relevant while we see moving from the formal nature, from centralization to the principles of decentralization. How to introduce this regulation, acts of planning becomes more important. So there are no just sufficient other instruments in practice, and moreover in legislation, that the character of these acts have not been defined clearly. As we see, some scholars already underscored this. Mr. Tymoshenko, there is much discussion whether there is a normative acts or these are virtual acts, or as it is suggested in the doctrine of the German law, a special act that cannot be brought to different. But there is an opinion that this is a comprehensive act which contains both the form and method of regulation. I would like to note that planning acts are accounted for regulation relations in future. It's one their particularity. The other particularity that always there's the subjects are not defined when will be that's all subjects of the planning acts as well as and subjects of the private law that they have been not specified in the typical examples which have been already brought to attention by the Administrative Cassation Court. I would refer to the acts of the urban development. In my opinion, this is a typical document that contains provisions of different character, of legal character. Some of them of legal character, some of them are not legal. There are some normative character. Other provisions are or have the not specified subjects. In my practice, if we take into account judgments, resolutions of the court of the 2018-2019, courts come that these acts have the norms of the law. That is the particularities of the should be applied as it relates to the normative acts with relevant placement of announcement to have additional terms for the appealing against such acts and so on. On the other hand, there is just some not certain practice of appealing out of the recent problems that were raised. I may just cite one case related to the formation of the amalgamated territorial communities. If we take into account perspective plans for the amalgamated territorial communities, then first, it is implemented through the resolutions of the Cabinet of Ministers of Ukraine, and based on their content, the procedure of appealing against the provisions are focused in the legal procedural norms provided for individual law enforcing acts. In view of this discussion, I would like, for the purpose of saving time, probably to skip to skip the analysis of some theoretical issues, but to express the following opinion. If we take into account the administrative procedural code, that is the law of administrative procedure, and some drafts of the administrative law codes. So one of the codes was already, one of the drafts was supported by the parliament in the first reading. We should start develop this procedure of determining the procedure of appealing against the planning acts. Just particularly what is to enshrine particular indicators related to the acts of planning on the content, on the form of adoption such documents, on the mechanisms of legal duties. In contrast to those opinions that were expressed by the other just authors with regards to the form and method of legal regulation, and as a fact, probably through they try to provide a separate procedure in the code of the administrative justice. Probably because of the shortage of time, I'm not able to unfold those ideas, which I would like to present in my remarks. But as I said, such an approach from the point of the material and procedural
акти планування могли б бути врегульовані
regulated as a separate tool, both in the form and method of public governance. That would increase the effectiveness. On the other hand, there will be more opportunities to ensure the liberties and rights. That's as planning acts are important to provide for social rights, because in all remarks today we heard that clear planning, developing of programs, understanding restrictions that can appear from the spatial planning to the financial planning might be in effect. Therefore, it seems to me the subsequent development of these topics could be in the vision of scholars and practitioners, particularly presently from the by the parliament. Thank you. I would like to say that the topic was not also prepared not only by me, by also my co-author Tatiana Karabin. I would be glad to continue discussion of this theme, including the attention will be paid to we have developed at Uzhgorod National University with regards to this. Thank you for your attention. Thank you, Mr. Lan. And we move to our last presentation in this session. The floor is given to Sergei Urbanovich, professor of the Lviv National University, named after Franco, member of the Scientific Advisory Board of the Supreme Court, Director of Law, Professor. Professor, I hope, will demonstrate a clear connection between the science and the practice of the administrative law. How to define judicial jurisdiction in cases of appeal of the decision of the local self-government body of the determination of the healthcare of community form of ownership. You're welcome. Good afternoon, dear colleagues. First, I would like to thank all the organizers for very informative conference, for the invitation to participate in this conference to discuss such immediate issues. I hope that briefly within the boundaries of the time schedule, I'll try to bring some key messages of my presentation, which relates to a rather narrow specific issue, which has become very topical. Well, which became evident and very relevant in the course of conducting the medical reform, which relate to Article 49 of Constitution of Ukraine. As for non-allowing the reduction of the healthcare facilities. By late 2019, in the legislation on the healthcare, the Article 16 was added with a new part, according to which local self-government bodies carry out planning of the healthcare institutions and make decisions on establishing or termination or reprofiling of the healthcare facilities independently and in view of the development of the hospital district or hospital districts. So, on the other hand, the lawmakers also specified the frames for the local self-government bodies. The document, which is aimed to provide for the coordination between the national interests and with the local interests while certain decisions are made. Regretfully, in practice, this provision, this norm, are not complied with. And some local self-government bodies make decisions on the termination of healthcare facilities because of the absence of the approved plan for the development of the hospital districts. Because as for the development of the level medical services to the local population, then it aggravates their conditions. And then the judicial protection of the healthcare issues, also protection of the interests of the members of the communities confront some difficulties. On the whole, the problem has a partially latent character, therefore, some separate references can be found in judgments of the Supreme Court. In cases where plaintiffs are either individuals themselves or the healthcare facilities. At the level of the first instance courts, the question emerges: what is the jurisdiction for these complaints? How to appeal decisions against decisions of local self-government bodies on the determination of the healthcare facilities? The emergence of such a question explained by two factors. It's some differences in legal stances of the Supreme Court, to which courts refer. As for the legislative regulation, it should be noted that of 2004, it turned out to be enshrined in the Article 283 of the Civil Code of Ukraine. And so the authors of this code were against this provision, but nevertheless we have this situation. Principles of the healthcare system specify that the powers of local self-governing bodies include the implementation of state policy in the field of healthcare. At the same time, local law of Ukraine on local self-government enshrines contemplates just powers of Oblast Council to resolve the issues on managing the facilities and the communal ownership, without specifying direct connection how to implement, how to exercise this power, and how to exercise the national policy in the different fields of protecting human rights, particularly in the field of healthcare. So these deficiencies should be dealt with through the case law. The decision of the Grand Chamber of the Supreme Court, and I should already mention about this practice. It's really difficult to systemize criteria for the elimination of judicial jurisdiction. How to classify it by the character of the dispute, as subject of dispute, nature of the disputed matter. We have the following situation. Acts of local self-governed bodies on termination of healthcare facilities are of dual character, because being on the one side, acts of the managerial administrative activities, at the same time with regards to the healthcare facilities of the ownership are the form of organizing the organizational activities. So it hides the complexity of determining the legal character of such relations. Presently, my generalization. So the stances of the Supreme Court in this and other cases allows me to generalize the set of criteria that indicate into the public legal character of the dispute. So first, the criteria relating to the subject of dispute. So it relates to the specified now of the individuals. It relates to the interest of the community, but also if it is regulated, then it is for the administrative justice. And the third additional is there also the powers of that these are the competencies of these self-government bodies. There is another criteria which is rather difficult to apply because of its quite abstract character. A legal inequality of the parties to the dispute on these relations, and decisions on the basis of which such decisions are made. The decision of the Grand Chamber of the Supreme Court of January 17, 2010. It's also of May 2018, and some decisions of the administrative courts relating to the disputes on appealing against decisions of the self-government bodies on the termination of the educational facilities. As I said, these are similar. These are cases that are similar in nature to cases of termination of healthcare facilities. On May 27, 2020, the Grand Chamber of the Supreme Court considered the case in which it formed the legal position. At the first glance, in the opinion of some judges, which this has been different from the positions I mentioned earlier. This case, that's the through this decision, the court decided to leave unchanged the position with regards to the application of the deputy prosecutor of the Lviv against the decision of the district administrative court, which related to the illegal declaration of illegal cancellation decision, so-called district council. It mentioned that so-called municipal institution, while managing the property of the community, but there are different decisions here on just establishing this municipal facility. On the one hand, there are no grounds to make the conclusion that because of making a decision in this case, the previous legal positions of the Supreme Court have been changed. Because the final word should be said by the Supreme Court itself. Well, in summary, I would like to draw the attention to the reasonable steps made by the Supreme Court on just legal status of public interests in respect to law government exercising the residual powers, particularly in cases appealing against the changes in the scope of the healthcare facilities network. Thank you for your attention. If there are questions, I will be at my pleasure to answer them. Thank you, Dr. Rabinovich. Now, speaker, we have had the largest section, and we have stepped outside the time schedule. Now, if we were in the time schedule, we would have the time for questions and answers. As it will not be correct to delay the start of the third session, probably we would very briefly comment that there were questions from the participants and attendees. The associate professor from Yaroslav Mudry University, Koncharenko, put the question about what is just efficient is the institute of the model case. What improvements should be made with regards to this institute? This institute is quite new. So far, it doesn't require any amendments. But this is a new concept. Now, 62 model cases were resolved. This is an efficient tool. It helps to provide for quick judgments in some cases. So the cases after being considered by the courts of appeal are no more sent for the consideration by next instances.
There's a question about the Namibian exceptions from Donetsk National University. The question is, how often do judges apply Namibian exceptions to protect the rights of IDPs? They do. And we mean here the document about the documents issued by the occupation authorities. In Ukrainian case law and court practices, we analyzed all of those referrals. They are not frequent. Only 23 cases has such referrals because the consideration of such documents issued by the occupation authorities is important when you calculate the work record or the time of education of studies at certain universities. But the document itself is not recognized, only the information contained therein is taken into account. And now decisions about the payment of pensions that might fail to get executed for years. I suggest that we actually complete this the second session and have a 10-minute break. It's 3:41 now. I would invite you to come back at 15:50 and we will be speaking about the third section and it will be about procedural remedies. Thank you.